Good morning. My name is James Fox. That's accurate. I thought tell a little about myself, my insurance background. I always say in law school I saw an insurance class and said I don't know why I'd ever take that. So I didn't take an insurance class in law school. But then I was a law clerk in the Superior Court and fell in love with doing coverage cases with the judges who really didn't want to write those opinions. So I worked on them for them. And then through that, I got a job for a guy named Andy Dunn at Divine Millimet and Branch. I did insurance coverage work there for a while. And I moved over to a place called Riverstone, which is in Manchester, which was definitely a different environment. And then I ultimately ended up at the insurance department as Emily, and then I became the P&C director. And I've been at the department now for I think like 13 or 14 years. And learned from a bunch of people that had been there for 20 years. So I was thinking on the way in this morning that my knowledge goes back probably 30 years at the department. We were supposed to speak about legislation, which we'll do, but we didn't do a lot of legislation last year. So I think I'm just going to try to mix in a little bit of why we did stuff and historically why some things are where they are. So we had, I think we have 4 statutory issues that we're going to address. They're all in our technical bill, which is HB 499 this year. And I wanted to say before I start. So yeah, I said I've been there for 14 years. So I've changed so many statutes. Will Infantine's brought in a bunch of stuff to change. But we've changed a lot of stuff. But is there something that you as a producer, think, this doesn't work right. I don't understand why they do it this way. There's a better way to do this. The department, you should change this. You should contact us and say, this is what I was thinking about, and we'll definitely consider it. And you can call me directly or talk to Joan. Joan can get a hold of me too. And my number is, every number in the state's 271, so you don't have to remember that. All you have to remember is 2502. That's me. 2505 is a farm bulletin, so I also get a lot of phone calls from farmers asking for the bulletin, which I call back and say I'm not the farm bulletin person, but that's 2505. But okay, so our first change is to 402B, which really doesn't involve you guys, but it's that's the adjuster law, and that's been around for a very long time. And the reason we changed that one is that there are really 2 issues. For years and years, there's been like a debate even within the department on to what extent you need a New Hampshire adjuster on a claim versus an adjuster from another state. So let's say you took your car in New Hampshire and you drove down to Massachusetts to go to the Cape and you got in an accident. And then you're going to get your car fixed in Massachusetts, for example, because you're there for the summer. Some people took the position that then you didn't need to have a New Hampshire adjuster because it's in Massachusetts. The lawyers at the department disagreed with that in the sense of that these are New Hampshire insurance policies approved by the state of New Hampshire, and they should be, in terms of regulatory, they should be administered consistent with our regulatory laws, even though the tort law for the accident would be in Massachusetts law. And that was just a classic case of back and forth and almost like a bit of a negotiated settlement with some other people in the department. And so what we decided to do this year, we decided just to write in, so we added, the original version just said you needed a New Hampshire adjuster as an insurance claims adjuster if you act as a claims adjuster in this state, and that was the issue. What does in this state mean? And some people would say, well, that's if they bring the car back and they fix it in Nashua. Then we have jurisdiction, which the lawyers completely disagreed with, and I agree with them. So what we did was we added a few words, which then solves the problem, which is always the best way to do stuff when there's a potential ambiguity. So we said you need a claims adjuster on policies written on risks located in this state. So that clarifies, as you all know, that's really the jurisdiction for the department is risk located in this state. So we added that. And that was why we did that one, if anyone was ever wondering why in a technical bill something's there. And then the second one is we added, so this is the adjuster law, and we added the words, including unadmitted surplus lines companies. Now, the reason we added that does go back, and Will was probably here for this, but does go back many, many, many years. The old version of the department used to be, basically, we have a bunch of insurance statutes and regulations. We're the regulators. We know how they're supposed to operate, and then we just, if there's a question, we say, this is how it's supposed to operate. We did that in terms of unadmitted surplus lines companies at one point in time, saying basically that we don't regulate them. So I'm sure everybody here knows we regulate the admitted companies. And the Supreme Court, who aren't really insurance people, but very bright people, they told us that no, where in your statute does it say that you don't regulate surplus lines companies just like all other companies? And I wasn't there at the time, but I think the Department of Justice is the one that represents us before the Supreme Court. I think they were like, well, that's a good point. So to fix that, after Grand China, if you go to a statute called 40524, which is foreign insurance companies, it says, so the Supreme Court, this is classic. So we have our statutes and we say, this is how they work. And then the Supreme Court says, that's not how they work. And then for us to fix that, we're going to the legislature. So we went to the legislature and we changed the foreign insurance company law to basically say, none of our laws apply to surplus lines companies unless that particular statute says it does, other than unfair insurance trade practice. Unfair insurance trade practice applies to all insurance companies. But then that does, sometimes we come across something and we're like, wait, did we want that to apply? Or no, maybe we should have added that. So we had a situation with a surplus lines company, and then they were using an adjuster who wasn't licensed in the state of New Hampshire. And then we were like, well, should that person be licensed? And then it was kind of, again, a back and forth about, well, that statute, the adjuster's statute, doesn't say that it applies to surplus lines companies. So that was one issue, and then one group. And then the other group was, yeah, but it's the adjuster's license. They're still adjusting insurance claims, so that it's the adjuster piece that matters, and therefore they should be. And that, of course, went back and forth, and then without a clear answer. So the result was just to comply with Grand China and make it clear, because if we don't make it clear in the new world, so the old world was we just said this is what the law means, and then everybody pretty much did it. The new world, we say this is what the law means, and then more often we get back, that's not true. And then we read it and say, well, you got a good point there. So to avoid that, we change laws more often now than we used to, although things have gotten pretty clear. So now if you ever have a situation where you have one of your insureds come in there, well, unless you have for us, Bob, if anybody here does surplus lines, and they're upset with their adjuster and they're not licensed in New Hampshire. Pretty much all adjusters adjusting claims should be licensed in New Hampshire, and that means basically it's a New Hampshire insurance policy. So that should clarify things. Now sometimes we think things are clarified in 2025, and then maybe 6 or 7 years from now, maybe a different group of people will have to change it again. But we think that one's pretty clear now. So that one's done, and then so the next one on my list is. We just talked, so this is another surplus lines thing. So another question that had come up many, many times is, because of that Grand China case and how we changed the law, is that we do, as many people know, we do examinations of insurance companies. We don't do many examinations of producers because you guys have a little bit of a better situation. So if we come in and say, well, we're going to examine you and there's no problem, then you don't have to pay any bills. So you have a much stronger position than the insurance companies. The insurance companies have to pay for the examination no matter what we find. But one of the issues that come up is we also do investigations. And as I said, the surplus line statute, which is the foreign insurance policies statute, says that 417.4 applies, and that is the unfair insurance trade practices. And that does have some language, that's what I'm about to say, but it's not as clear in my mind as it could be. So that's how we do insurance investigations. So when I say 417.4, the biggest one in there is unfair claims practices. So the statute is unfair insurance trade practices, and within that is unfair insurance claim practices, which is you must do reasonable investigations, you must act promptly, you need to settle fairly, all of those things that allow us to basically change the position of an insurance company, particularly on a settlement if we don't like how it looks. If people here don't know how we do those, because that might be helpful for you in case you have an insured come in, is that we don't take the jurisdiction away from the Superior Court. So Superior Court will do coverage cases, and they'll do a lot of that work. And if it's you know, both sides have a good argument on something, a claim, then we say we don't really have jurisdiction over that. But if we think there's a set of facts where clearly, and I mean maybe not clearly, that might be a little too strong. If we think the insured or the claimant has a really good argument, then we will then push the insurance company and explain that they're in danger of crossing the line into unfair insurance trade practice, then that does trigger our jurisdiction. And then there's also the concern that if sometimes if an insurance company does it once, they might be doing it more than once. We use that a lot. But one of the problems with this investigation statute is that the investigation statute's in another section. It's not in 417. It's in 400A16. So that's like 400A is our general insurance department statute, and that one does not say does not and has never said that it applies to surplus lines companies. And the problem with that is the statute we use to tell the insurance company, here's your question, and you must answer us in 10 days. They can ask for an extension, but generally they're supposed to answer us in 10 days. But if that doesn't apply, then it's like, well, they don't really have any deadline to answer us. So what we did was we took the end of the foreign insurance company statute, and we just added that. So it says basically that 417.1 through 417.22 applies, and then we added, and investigations under 400A16 with respect to any statutory regulatory provision to which unadmitted surplus lines companies are subject, which then basically circles back to 417. We probably could have wrote that a little differently. So that was basically, I would say, the goal of both of those statutes was to make clearer our authority over the surplus lines companies. And if you don't handle surplus lines well, there's a little, you can take that home as trivia, I guess. The next one is that we did is something that I think you guys probably would be interested in. Not the change we made, but the issue, because the issue's been at the department for years, and we're still working on it. But the issue was that there's under 417.4, 417.4.8E, there's a list of things that you can't refuse to write. So insurance companies say, yeah, we're not going to write because of that. And they're the ones you would generally think age, race, color, creed, national origin. So you would think, yeah, you wouldn't have somebody say, we're not going to write someone because of their race. That would obviously look pretty bad in the public, but we would obviously say, whoa. So we got underwriting guidelines, and if that was in there, we'd be like, whoa, you can't do that. But one of the ones that's in there that has been much more controversial is it also says you can't refuse to write solely because of place or area or residence. And that's what we generally call, you can't refuse to write based on location. And it comes into play in like homeowners a lot. There was a typo in that. That's been there for a very long time, but we decided to fix it. And so it says currently place or area or residence, and it really should have said, and this is what it says in other areas of the statutes, place or area of residence. And so, the controversy that came out of this is some people have interpreted that to be a redlining provision. So I think this came out of more like New York City, that the insurance companies wouldn't write certain area codes because not area codes, zip codes, because of that was a community of a particular minority, and that was obviously not good. And so the change was to basically say, don't do that, don't do redlining, and that already would violate the race. And our statute could have said no redlining, but we did the legislature. This all goes back to the legislature. We're basically being forced with the legislature's will. The legislature chose to put don't refuse to write based solely on. And solely's got its own other issue that we don't need to get into, but based on place or area of residence. So the department takes and still does, takes a very strong view that because It doesn't say redlining, and it just says don't refuse to write based on, I'm going to make it collapse it, location, that you can't refuse to write. If that's the reason you're not writing, you can't do that. If you want to go out and do traditional underwriting and say there's other reasons, the roof or something, that's fine. But you can't say we're not going to write based on location. We don't even want it in there. We don't want to, the solar thing, we don't want to say we're not writing because of the roof and because of where you live. We just don't want it in there. And so Christian, who is right over there still, Christian spends a lot of time looking at the underwriting guidelines, and which is, thanks, we all thank him for doing that. And he will pick these things out, and then he will tell the insurance companies you can't do that. And we get quite a bit of pushback, and we always have, and we get the repeat argument about, well, this is really redlining, so why are you doing this to us? So we have taken a strong position based on the language, but there's behind that, there's some color behind that too, in the sense of there's a concern also that if we start right or wrong, that if we start allowing companies just to refuse areas of the state, then we might arguably head for a fair plan. Not saying we would head for a fair plan. The department on those kinds of things are very cautious, I guess I would call it, because we had the Med-Mal JUA. You may not be aware of that one, but a JUA shouldn't be competing with the voluntary market, and in that case, that's medical malpractice. JUA, that one did compete with the voluntary market. It was cheaper than the voluntary market. At the end, they weren't even using forms. Basically, if a doctor had a claim, they just paid it. So we're very cautious to go to any of those types of facilities like we have for auto, or expanding them at all. So I think we've always thought the location rule it works well, but we have obviously had people come in and like I said, you can and talk to us about it. And so we spent I think over the last year reviewing it and taking in opinions about what it should be and what it is, and then we did a letter. I don't know if everybody here got the letter. But I'm sure Joan did, so you can ask Joan for it if you want. I assume Joan got it. I hope she did. But the letter basically reiterates our current position, which is you can't not write based on location. So if you have a situation and a carrier is doing that, and you want to bring it up, you can tell them it's not allowed. I already gave you my phone number. Tell them they can call me. It's 2603-271-2502, and I will talk to them. It's a very bright line rule right now. But while we were doing the review, Emily, our able attorney, she found that there is a new version of the unfair insurance trade practice law that has extra language. So the newer version doesn't just say don't write based on location. It has a little more nuance to it. So the commissioner did agree that we would take a look at that and see if that is something we could change to. And when I say we could change to, that would be us basically adding some words, and then we don't do anything ourselves. Going to the legislature, explaining just like I did to you, here's where the world is, here's where it would be, and then the big I would testify, and I don't know if everybody knows, but probably the largest lobbyist is George Russo's for what they call the domestics. So that's a bit of a misnomer because any insurance company can join that group. He represents them, and also Jim Hayden, who represents State Farm, and I know that's a captive, but as far as producers go. But yeah, so that's going to be this summer, and if it is going to change, so those of you who don't know, if that's going to change, and everything else we decide to do. So we basically, legislation's wrapping up this year. And then what we do then is we start thinking about next year. And then we start going, okay, this should be fixed, this should be fixed. And then over the summer, and then we kind of pull it all together over the summer. So this will be one that gets pulled together over the summer, it doesn't. And then we send it out to basically any insurance professional who wants to look at it. So if you also want to be on the list to get it directly, I mean, Joan's going to get it, but you can also reach out and get on the list of people we send it through email. And then you get a chance to opine and say, we think this is a good idea, we think that's a bad idea, don't do this, don't do that. And usually Will, I keep saying Will, because he's at the department a lot. Will usually comes in and he has, well, it used to be Will and Chris Nicolopoulos. They come in and they say, here's what we think about all of the different changes you're proposing. So there is a very active producer input on what we do. But that's pretty much what we did. I think Josh also talked about the 415C companies. I don't really, I'm not sure I'm really going to get into that because I'm not sure that's really valuable for you guys because that's not sold through producers, that's sold through sellers. The next thing we wanted to talk about, we did a couple of bulletins. So I think we're supposed to talk about bulletins. So the department, I would say, historically, I think the first 10 years I was at the department, I don't think I did any bulletins. And now the new commissioner, he wants to, let everybody know what we're doing. So we have a lot of little, this is what they look like, little signatures with Commissioner Bettencourt's name on them. And so the two that we're going to talk about is one, we'll start with the first one we drafted. And so when we draft this, again, so we do a bulletin, it's much like legislation. So we draft it, and then we circulate it inside the department to people who are involved in that area. Like, if I draft it, Emily would get it, Christian would get it, the deputy commissioner gets it, the commissioner gets it, assistant commissioner probably would get it, the general counsel gets it. We all go through, this isn't clear, you got to change that. And then again, those go out to industry and we take more input to make sure that we're exactly where we want to be on clarity. And that doesn't mean we take it. Sometimes the stuff we get, we go, well, no, that's not what we want. So, obviously, especially, some of the lobbyists will be like, well, we changed this sentence, but then it's like, well, if we change that sentence, it changes the whole bulletin, goes the other way. So we don't do that. So what we had the first one is roofs, the exciting world of roofs. And that we tend to get consumers who call and say, the insurance company is saying they won't write my house unless I fix my roof. There's nothing wrong with my roof. I went up on my roof, which is always scary. Sometimes I wish they wouldn't do that. I went up my roof. I took photos. I had it done recently, and the insurance company is using drones basically. And they won't change it. They said they've made a decision. They say we filed guidelines with the department that says we use drones, and so they just refuse to do it. And we've been in. So one of the other things we do is we do consumer complaints, and we all sit around a table. I'm there, and Emily's there, and the consumer people, and we go through every single consumer complaint gets reviewed by me and Emily. And the insurance companies were, some of them, not all of them, they were just taking a very hard position saying that we don't have to. We told you what we do and you signed off on it. And then we told them, which is the truth, we make mistakes, so even if we signed off on it, we're unsigning off on it and you need to fix it. And so now the new bulletin, I'm not going to read it because it's too long, but it basically says that if you're contacted by if you say you're not going to basically write it or it's going to be more expensive because of the condition of the roof, and you have the consumer disputes you, then you need to send a human out to take a look at the roof. You can't just stick with the photograph you took. That went out, and I don't think that was overly controversial. I don't think we had some language that people didn't think was very clear, but I don't think the companies were particularly upset about it. So that went pretty smoothly. So we did that one, and while we were doing this one, we had another one that came up. That's been an issue that's been at the department for a while, and just to step back again. So we said, we had an insurance company that said, well, our procedures, we don't go out in person for that reason. So the other one that came up is so what we say back is, well, the reason we say you have to do that, we don't just say because we think that would be nice. We say you're in danger of being an unfair insurance trade practice again. That is basically our catch. There's a certain level of reasonableness. If they go past that, then the insurance company is usually in danger of a charge of unfair insurance trade practice, which is a very bad place to be. So the other one that came up, so we're doing that for underwriting. And then I think it was the deputy commissioner said, well, shouldn't we also do one that says that for virtual claims adjustment systems. So this one I'll actually read to you. So this one's about virtual adjustment of vehicle claims. And this is much shorter. It's really only one paragraph. We cited again RSA 417.4, which is what we cite. And in this case, it's the claims one. But what it says basically, while virtual claims adjustments, this paragraph, by the way, was edited so much that it was, you would think it was the most important paragraph ever written. While virtual claims adjustment systems may help settlement claims more quickly and reduce costs for the insurer, photographs and videos do not always reveal the true extent of damage a vehicle has sustained. Consequently, to comply with the Unfair Claims Practices Act, insurers must provide an in-person inspection of a damaged vehicle within a reasonable period of time if requested by the consumer. Insurers may not deny a consumer's request for an in-person inspection on the grounds that the consumer initially elected to use a virtual adjustment system. Further, unreasonable delays in making in-person inspections may also be considered a violation of the unfair claims practices. If it rises, again, so this is what I was trying to say, and this is like, it's a little bit of us doing a reasonableness test, which is basically what almost all tort law is based on. If it rises to the level of an RSA 417.4 violation of duty to promptly and reasonably investigate. So that's what he says. So basically now, insurance companies know, they're on notice up front that if there's I think usually there'd be a dispute, but if the person, even if there is a dispute, the person wants them to come out, they have to send somebody out to take a look at the vehicle. That one had, as I said, that paragraph was edited, and I don't mean internally, I mean the people who commented on it, there was pretty heavily commented on. But we think it's pretty clear. We think it's important for consumers to think, there's, in the law it was called when I learned it was called the Mikeman values, but people, like DJ was, we were talking to some people yesterday too, and the commissioner said that even when the department we rule against people, which we unfortunately for them we have to fairly often. They usually understand that we explain to them, we go through it, why we had to rule against them, what the statute is, what the rules are, what the extent of our jurisdiction is, and we give them a recommendation on how they should handle it. Like I said, if it's something that's really handled by a more like a court situation, we kind of point them in that direction. So usually people are satisfied when we've done our process, and I think this in-person option for consumers helps with that too for insurance companies. So I think it's positive for insurance companies, but that one page bulletin until Commissioner Betancourt came in did not get out the door for, I think we started talking about that 5 years ago. But I give it to Commissioner Betancourt's credit. He has definitely taken a strong look at everything we do and said, where do you think there's violations that may be harming consumers in terms of how their claims are being handled, policies they're receiving, etc. And he's been not afraid to take stands on things. So I give him a lot of credit for that. And he's also spent a lot of time, learning all the ins and outs of regulation. We all know insurance from whatever direction we come from, but I always joke with the forms compliance people that my background was at Divine Millimet doing insurance coverage cases, where what I got was basically a lot of times it was the same issue over and over again. The issues that are in the policies are in dispute. There's a guy is at a party, he drinks too much, he punches the guy in the face, he falls off the deck, and is that covered? Is that an accident? They didn't mean to hurt him. Is it inherently injurious? So I do those over and over and over again. But all of the stuff that actually is covered on the insurance policy, I actually learned at the department because we never did that outside of like, oh, that's covered? Okay, interesting. So I spent a lot of time with the forms team making sure that my interpretation of insurance policy is consistent with their interpretation. And I will say, if you ever have one of those questions, if you want to call somebody at the department, you can call, and you can find our phone numbers online, by the way, if you search New Hampshire, I think, directory. Is Lou Ann King. She does all of she's in charge of the forms team, and she does, they review all of the forms. If you think something isn't being interpreted correctly by the insurance company, or you think it's bad language, again, you can let us know about that, and we can take a look at that, because again, the way our forms team reviews that statute is we review things for direct violations of any New Hampshire insurance statute. And unlike anything in claims, they're the only entity at the department that has the real power in P&C land to say, we just don't like it. We can disapprove we would disapprove a form for being against the public interest. So, and again, that would not just be Luann. So how that works is if a form comes into the department and Luann flags it and says, hey, this is, the insurance company wants to do this. I can't see that it violates any of our particular statutes, but it just seems really bad for consumers. Then she talks with her team, and then they come into my little windowless office and they tell me, we don't like this, what can we do? And then if I say, yeah, this sounds bad, then we go get Emily, and then she confirms the legal position of it, and then we go up to my direct report. I direct report to the deputy commissioner. We bring in the deputy commissioner, and then ultimately the commissioner, he makes the ultimate ruling of whether he views that as against public interest. And so then how we do it is then that would get you can't do this, change your form because it's against the public interest. And then we're back, but that's only a temporary fix because we don't want a long list of things we've just declared to be against the public interest. And then we go through, again, we're back to the legislative process. We propose a new statute, or we do a rule. We didn't talk about rules, but we also have rules. And then we go through those processes, and we ask the legislature if they agree with us. All the industry people usually come in. We don't really have, we're probably the consumer advocates, but we don't have any independent consumer advocate that comes in. And then the Commerce Committee is where we go. John Hunt's been running the Commerce Committee for, I think, 30 years. He's a Republican, so as long when the Republicans are in power. And then ultimately, it goes through the legislature, and if it passes, it becomes the law. And if it fails, then the legislature has spoken, and the insurance company we reverse direction. I would also say that one of our goals as the department is to always comply with the law. So even if we've been doing something the wrong way a long time, if somebody brings it to our attention, we don't continue to do it the wrong way. We acknowledge we've done it incorrectly, and when we change directions. And it's very important at the department that everybody that we hire grows and learns to regulate that way. It wasn't, probably when I first got to the department, a woman named Chiara Dolcino was trying to change that to be in that kind of mold. The old mold the problem was we had a lot of our people come from industry, and then it would be like, well, we didn't do it at Travelers that way, so I'm not going to let that happen. So we're all open-minded people, as we're supposed to be, so you can call us on that. You say, hey, call me directly. You said you're open-minded, you're doing this wrong, and you need to fix it. But now we follow the law, we go through processes at the legislature if we think we need to fix things. I'm very proud of the team we have. Maybe some people know we have the federal, and then the federal level they have DOGE, we have COGE. We were talking to the COGE people yesterday, so we're a commission on government efficiency. And I was saying, we're in the P&C division, Christian, myself, and Emily, but if you actually went past three of us, you're only going to get about 9 other people. So the division in the state of New Hampshire for all that we do is only, I think, 11 people. We work together. We work very hard to make sure that consumers are protected, consistent with the laws. And if we see problems, we go to the legislature. So I guess that's my little spiel on the legislative this year and how we generally do things. And again, I give a speech about contacting me, and every time I speak, and nobody ever calls me. that doesn't usually call me. And then I gave a speech on flood insurance, and same thing I did. This is how flood insurance works. And a woman actually called me from Rye, New Hampshire, and I was so shocked. I was like, oh my God. I was thank you very much for calling. I'm so glad you called. I gave her I'm gonna work on this immediately, and so I gave her a bunch of links and everything, and but yeah. So again, I guess I will just end with, and if you have questions, that's fine. But whatever you want to ask about, don't worry. It doesn't be legislated. Anything P&C, Emily, myself, or Christian can answer anything. Maybe not correctly, but we can answer it. That's a joke. Yeah. So I guess I'll just end with that, and thank you for inviting us. I always like to chat.
Joan has a question.
I didn't say I'd take one from Joan. Anybody else? Anybody else? Oh no, I'm sorry. I'm gonna let Emily answer the questions. I'm getting tired.
Everybody hears me ask this question.
Oh, you want to use the microphone?
Yes, because this is very important.
Yeah.
Okay, I get calls often, very often, about surplus lines brokers who require the agent to get 3 declines and give, see, I do it. And they have to get the underwriter, give them the name, they have to, in some cases, they even ask for a letter of declination. That is not how I understand the law. That all that we as in all of us, have to do is satisfy the insurance commission.
I can answer that one. I'll answer this one because this has been there for a long time too. There was a letter a long time ago which I used to have. I can't even find it anymore. There was a woman named Deb O'Loughlin who used to, and people who know her name's O'Loughlin, not O'Loughlin. But she's not the department right anymore, and she gave me all the important letters to keep, and of course then lost them. Because the old days we used to type up letters and then have to retain them. Joan's correct. So actually, it's the statute we've been talking about, RSA 405-24. So 405:24. It says you have to satisfy the commissioner, and then I would say if it's something that we like, well, I think you should be able to find that in the admitted market, and then we'd want you to at least once try, and that's where the three strikes came. So if it's like a really gray area one, you're like, and you think if we saw it, we'd be like, wait a second here, you can get this. And just to be clear, because it's this question, a lot of these little questions will come up. So let's say the first pass through, it's a close call, whether you can get it or not. And the issue is whether your agency can get, you have 3 companies won't write it. We had one person once tell us, I can write it, but they don't write for that company, so I want to tell them they basically bring the business to me. And I was like, no, we can't do that. That's too far. That's too much for a burden. So I would say there's that. That is one way to do it. You'll always be very clean and you'll be very protected if you said, hey, we know about the 3 strikes rule, and Lisa's on there, like, yep, that's the 3 strikes rule. But on the other hand, I always say if it's something that clearly, absolutely cannot be sold would not ever be sold in the admitted market, it's not an admitted market thing, and you're comfortable with that, then I am comfortable saying that Emily would be, but I'd be comfortable saying, because so there's a statutory issue that Emily would usually interpret, but basically she's going to tell you, she would tell you, and this is my opinion of what she would say. It's not. I'm not going to. She doesn't have to keep this. That she would say this really just raises a policy issue, and then it's an issue for the commissioner. And I've talked to the commissioner about this, and this just keeps rolling forward on the same process, which basically we're using common sense. If it's something obviously cannot be sold in the admitted market or isn't sold in the admitted market, then that's going to satisfy the commissioner. Obviously, it would be ridiculous to say you have to go get 3 strikes when it's clearly would not be written. But if it's a close call, then I would probably get the 3 strikes. We don't say they have to be anything. You can just put in your notes who you called and when who you contacted, and then it was a no, and then that's fine. There's no formal requirement. It's just that's the statute, and if we wanted a formal, so this again is how it works. So if that's a statute. If we wanted a formal requirement, then we would do a rule, and then in the rule we would say you must do these specific things, but it doesn't say that. So that's how that works.
Just really quickly, I had a question from one of our members, and I answered it with what I understand to be the truth, but then I started questioning myself. If you have a surplus quote and a standard market quote, do you have to legally give the insured the standard market quote? Or could you offer them both, or even if the surplus quote maybe had better coverage, better pricing, could you offer the surplus quote?
You're not supposed to go into the surplus market if it's available in the admitted market. So they should go with the admitted quote. I would say the one little maybe, caution in that is there is at least an argument. So that would be the general rule. Because the quality of the company, there's a lot of stuff that we don't regulate in surplus lines. But there probably is an argument that if you could say the actual parameters of the coverage, the scope of the coverage is not the same what they want, or that it's so much, more expensive, if it would be in the admitted market, then you might have an argument that what the person is looking for is really not available. I think probably it'd be a straight face test, but generally we want you to stick with the admitted market. But if it's as I said, if the scope of coverage is different, and then the fact that they're both titled something isn't going to be the end of the story. If somebody's like, I'm looking for this type of coverage, and this is what I want, and then you get a quote in the admitted market, and you're like, well, we'll only do this, not all of that, and then the surplus lines market, they say we'll do all of it, then I would say it's not available.
So, sorry, just to follow up.
By the way, this is why sometimes when Joan asks me a question, I read it. And then she doesn't think I respond, but really what it is, I read it and I go, oh, that's a good question. And then I go, I'll have to think about that. And then I start thinking about it, but then somebody comes to my office, then I'm down the hallway, and then I'm like, and then Joan eventually either emails again, can you please answer this, or calls, and I'm like, and I don't not want to answer it. It's more like I just don't want to give a bad answer.
So, again, I just want to clarify. If you have two quotes on the table, one is standard market, one is surplus, can you offer both and have the insured make the call?
I think you need to stick with the admitted market. That's what I'm trying to say. You got to be in the American market. You're not supposed to move into surplus lines otherwise. But that could be a statutory change. I mean, we could, I was thinking I might want to read the statute again, but I think that 40524 says you're supposed to stick in the admitted market. But again, this is one. This is something. If I think this actually, I think Joan did come in on this once, and we didn't change it. But if at first you don't succeed, try again. Maybe we will change it. There's a person way in the back by the coffee machine, which my coffee's cold.
I just wanted to add on that because we've seen in our office, Big I, we have an agent call in and say they have an admitted quote on a homeowner's policy which has basic perils only. Okay, and they have a quote from the surplus market, which is special perils. Clearly, there's a difference in conditions and coverage. So, my erring has always been to tell the agent to offer both. Now, I'm confused again because I have an admitted quote which has inferior coverages.
No, that's what I just said though. If the coverage one's inferior and one's superior, then I think you're talking apples and oranges, and then you can say what the person really wants they can't get. So that would be different. So if what the person can get is in the admitted market is the same as what they get in the surplus lines, and it's like a money issue, then that would then stick with the admitted market. If the coverages are different than that are available, and I would say they at least have to be significantly different, not like some minor thing you're trying to say, well, it's different. If it's as a straight face test, we're like, yeah, that's different. What you can get is different, and then they want to go in the surplus lines market because what they want is different. Then I would say that's okay. And Emily just nodded, so I guess that's good. Christian, I can't see because I don't have my glasses on, but
I'm giving her my own answers
yeah,
as we go.
yeah. What's that?
The company's coastal guidelines go against the location statute?
Oh yes, they do. Not if they're just saying you got to spend more. That's fine. I mean, it's about not writing. If you know, we've had companies say, oh, we don't want to write the coast because the reinsurance is too expensive. We can't get reinsurance for that. But we say, well, we can't change the statute. The statute says you can't not write based on location. So that really shouldn't be a consideration because it's not allowed. So, but the location thing has been around forever. Everybody, Christian, around forever? Yeah, it's been around forever.
The 10 years I've been there.
Yeah, it's, yeah, and that interpretation's also been around forever. But things do change. We used to have a really drastic interpretation of the rebate law, which you guys are probably a little bit interested in, but that changed. I used to enjoy watching things on the television where it's like, you know, they're giving something away, available in all states except New Hampshire. And I was like, I would laugh and go, oh, that's Kiara. That was Kiara's thing. She was so afraid that people were going to, she used to be general counsel, great person. She was so afraid that people were going to make the decision based on the rebate, not on the insurance coverages. And then if you went to the legislature, by the way, Representative Hunt would always say, I want a free toaster. Why are you against free toasters? So. Anybody else? Anybody that's shy, again, you can give me a call. You can be the number 2 person to do that. Wait.
Bob is not shy.
Just one more on that redlining issue.
Uh-oh.
So what is the difference between a company redlining and not writing, say, PC 9 or 10?
In New Hampshire, the redlining thing is not relevant. Basically, you could argue, I would not argue this, but you could argue that we're just being overly inclusive. We're saying it's not just redlining. We don't want to have to prove that you're doing it for, you know, racial reasons. What we just say is you can't not write based on location. That would bring in all of the and Joan's saying solely, and that would bring in the redlining. That does fix that. It's just basically if you're not writing on location, then it's illegal. We don't want it in there. So maybe what Joan. So if you're an insurance company, just go out and honestly underwrite it. And if you go out and there's like something wrong with the property, then that's totally understandable. But don't say we're not going to write it because of anything that sounds like a location. And we get all kinds of things that sound location. And you know, the Supreme Court has said a million times, in insurance land, we don't care what nomenclature you use. If what you're saying is location, then that's location. If you're saying you can't be more than 10 miles from the fire department, that's a location. Everybody who's more than 10 miles from the fire department. And so anything that sounds like a location, we just say no to, because it's not just that it's location. The reason I read those other things, that it's in a very important section of the statutes. That's the one that says don't write based on race. So let's say, and Joan was saying solely, let's say you're an insurance company, and would you want to write, we're not going to write because the person is Hispanic and because of the roof. No, you wouldn't do that. That would be like, what are you doing? So it's because location is right after that. Don't do that because of location too. It's just a matter of statutory interpretation. We have to give it the same importance as all of those other more generally protected classes because of where it's just right in that list. So we can't not do that. But that's why we are looking at some changes. Some other states have a slightly different language, and then that might alter things. But we haven't finished our review of that and where that might land. But we're going to do that, and that would then say this new version, these words are extremely important and don't do this. But when you add words or subtract words in statutes and rules, it makes a huge difference. That's why you have to always be very careful what words you use. I'll give a quick example. When I was doing a different area of the law, I had an agency that, so I was more like a lobbyist. I had an agency that would do X in every area except for this one little area. So I went in and put a statute in that said, they will do this in X. And I was like, there we go. Everything's going to get covered now. And then literally the agency said, which is, I understand, they're right. It's like, we can only do it in X now because you had the legislature say we can only do it in X. Now, wherever else we did it without any formal requirement, we can't do it there anymore because you should have just said, do it everywhere. So I always remember that one because that was such a bad mistake on my part. But the words, words matter, and especially in legislation, because we all have to live by them. That's why that phrase, "we're a nation of laws," comes from, not a nation of people. It really means we have to follow the law. Anybody else?
Now's the time.
We're right here. Or again, if you're shy, it's 271-2502. All right. Well, thank you very much. And I guess have a I don't know what you're doing this afternoon, but have a good rest of the day.